Okay, so we will see unit 2. Okay, in unit 2, we just have two topics. Okay, general defenses and vicarious liability. Okay, just two concepts are there. So these two concepts we need to study properly because you will get questions from these two topics, right? As such, we don't have a lot of topics that, okay, this is important, this is less important. It's not like that. Okay, so unit 1 was all about what tort is, right? Once we understand what tort is, what are the elements and everything.
Yes, ma'am.
Before starting with different types of torts, okay, it becomes very important for us to study general defenses. Okay, now do you remember the elements of tort?
Yes, ma'am.
Yeah, what are the elements?
Elements of torts are act of omission, legal damage as an element of tort, and legal remedy. So in legal damage, we study damnum sine injuria and injuria sine damnum, and this, ma'am, this UB just EB remedium also comes under elements only.
That
no,
is,
right?
No, that is not like an element. That is just a maxim that we have. Element,
Yeah, that's a
these three
maxim.
elements are only there.
These three elements, correct, ma'am?
Yeah,
yes, ma'am.
These three elements. So now, after studying unit 1, what we have understood is if these three elements are satisfied, act or omission, legal damage, and legal remedy. If these three things are satisfied, we can claim for compensation. That's what we have understood by far. But
okay,
even though those three conditions are satisfied, a person goes to the court, files a case, even then, okay, defendant is having an option to seek some defense. As in, he can say that, okay, fine, there was act or omission, there was legal damage, there is legal remedy. But even after these three conditions are being satisfied, I have something to say. Okay, there might be some specific conditions, what happened. There may be some specific situations that he can give in order to escape the liability. Okay, he can say that it's not that I did it with my own intention or I did it like this, but it was because of this that it happened. Okay, so general defenses in tort is nothing but 8 situations wherein even though the 3 essentials are being satisfied, defendant can try to escape the liability. If he can prove any of these 8 defenses, he can escape the liability. Okay.
okay.
So when a plaintiff brings an action against the defendant for a tort committed by him, he will be liable for it. That's the general rule. If you can prove the 3 essential elements being present, the person will be liable. If these 3 essential ingredients which are required for the wrong are being satisfied. But there are some defenses which are available to the defendant, him as in to the defendant, using which he can absolve himself from the liability. He can try to escape. Okay, I'll mention here. Defendant. So defendant can try to escape the liability which is arising out of the wrong committed. Even though wrong has taken place, he can try to escape it. And these are nothing but what we call as general defenses or exceptions. Okay, these are present even in criminal law. IPC, you study general defenses in criminal law. They are slightly different as compared to torts. But yeah, in IPC also you get general defenses. In torts also you get general defenses. And what are these general defenses? These 8 defenses we have. Okay. Is it clear?
Yes, ma'am.
All right. Now you need to remember all these 8 points. Okay. Like I said, as such, you don't need to memorize, but there are certain things which you need to remember. Like you need to remember these 8 points. Plus, it's not enough that you simply remember consent because it is easy to remember and you completely ignore voluntary non-fit injuria. You need to remember both because in exam, Might be you know consent very well, you have studied cases and everything, it's very clear. Question comes, what is the defense of voluntary non-fit injuria? And you feel like, okay, it's something different concept I have not studied, you might skip the answer. So you need to remember both the names for it, okay?
Okay.
So first one being voluntary non-fit injuria, it is also called as the defense of consent. The wrongdoer is the plaintiff, or plaintiff being the wrongdoer. Inevitable accident, act of God, which is also called as vis major or force majeure. Private defense or self-defense, mistake, necessity, and statutory authority. Okay, remember these 8 points along with this alternate names. All right. So we will see what these different types of defenses are. First one being voluntary non-fit injuria or the defense of consent. So what is consent?
Consent is ready to pay for his loss, something like that.
Consent is like approval once you agree. Okay, like yeah, like if I say, okay, are you free at 6:30 for a class? You say, okay, I'm free. As in you have consented that yes, I'm free, I'm available. Right? Consent as in agreeing to something. All right.
Okay.
So this defense basically says that if you were the one who gave the consent, then in such a case, you should not be going to the court and claiming for compensation. Same as voluntary non-fit injuria. Voluntarily, okay, voluntarily if you are coming, consent doesn't voluntarily you have agreed, right? There was no force on you, you only agreed. So voluntarily if you are doing something, if you are exposing yourself to some risk, that is not a fit case to claim damages. Okay, voluntary non-fit injury. If you have voluntarily exposed yourself to some risk, you cannot later on complain about it.
Like what, ma'am?
Like take for example, you would see that before any certain operation, doctor would ask the patient or the attendant to sign on a consent form. Have you seen that?
Yes.
And also, why do they do that? Because they want to take consent, because there are some risk involved in it, right? Like take for example, a person is struggling to survive, the person is not able to breathe and stuff, oxygen mask is not working out. Like oxygen mask is a simple thing that they can put. Oxygen mask is not working out. In such a case, when doctor decides to put the person on ventilator, they would not straight away do it because there are a lot of risk involved, right? A person develops pneumonia and so many other symptoms. And the risk of survival is like the rate of survival is also very less. So in such a case, doctor will not straight away put the patient on ventilator, but they would ask consent. Obviously not from the patient because that's not possible, but from the attendant, they will ask that you sign on this consent form. Patient is struggling to survive. Can we put the patient in ventilator or not? Consent will be taken. Same ways, recently I saw for MRI. MRI is also like a detailed process, right? So in MRI, I was not aware of it before, but I came to know recently that before going for an MRI, there also patient is asked to sign on a consent form where the entire process is explained in detail, that this is what the process is going to be. You need to put your signature. Same ways, there are a lot of different procedures, lot of different treatments for which consent form is signed. That does not mean that doctor can be negligent. They would just do whatever they want. They would just do the operation. Not like that. Doctor should not be negligent. They will do their job properly, but still, it's not like match, right? 1 + 1 will always be 2. There is always 50-50% chances person may survive, operation might be unsuccessful. That is the reason why they take consent, right? For all these different operations. So if take for example, you are voluntarily going there, once they have explained that this is what the process is, in the treatment, you will be given this, that medicine, it might have some side effects, you might feel some pain and some like discomfort and stuff, after that also you are going forward, later on you cannot complain that, okay, I'm having this discomfort, dizziness, this, that, because that was expected. The entire process was explained to you, and maybe that's good for your health, right? So in such cases, we can say voluntary non-fit injury. Voluntarily, you have exposed yourself to that situation, okay?
Okay. Ma'am, suppose see, as you said, during medical cases, now a patient will undergo surgery. So for that, anesthesia is given. Okay. So before that, they will make a patient people to sign for the consent form. Okay. Then what happens? The patient will die because of excess of anesthesia or something like that, or mistake of the doctor while injecting the anesthesia, amount of anesthesia giving, like more amount he might have given, or he might have given in a wrong way or something like that. So that is definitely a mistake, but still patient side people, they have signed the consent form. So do you think you can, I mean, do you say we can't go to court in this case?
We have consented for the operation. We have not consented the doctor can be negligent, they will do whatever. That is also considered as a service that they are providing. So if doctor is being negligent, there are a lot of cases filed under Consumer Protection Act for negligence, for ill treatment and all that. That you can definitely go. Consent basically means that you cannot say that, okay, how did they even, like do this, insert these things and do this operation. For that you have consented, that you are skilled enough, so I'm giving you consent, you do the operation and you save my life. But you have not given consent that, okay, you do whatever, be negligent. For that you have not given consent. For any negligence, even after a consent form, you can go to the court.
Okay, ma'am.
Okay. So in case the plaintiff voluntarily suffers some harm, he has no remedy for that under law of tort, and he is not allowed to complain about the same. The reason behind this defense is that no one can enforce a right that he has voluntarily waived, right? I only had a right that I can stay peacefully at my house, I can sleep, I can rest. But what I rather decided is, I decided to go on an adventure trip. I decided to do some adventure sport and stuff. Always there is some amount of risk, right? It depends on maybe the person's luck also and a lot of things. Even though it was properly maintained, well organized, everything was done properly, even then there is slight amount of risk if you are going for those adventure sports and all. Right? In such a situation, I cannot complain if they were not being negligent. Okay, because we do not know, like machines and stuff, there is no guarantee for it. Anything can happen at any moment. There it is nothing but voluntary non-fit injury. There is as such no, it was not like mandatory for me that I need to go on an adventure trip. I only exposed myself to the risk. So in such a case, I cannot complain about it. Okay, there are certain things where risk is involved. Okay, whatever is the situation, risk is involved. So if I'm voluntarily going there, I should not be complaining about it. There was a similar case where a person bought tickets to watch a car racing event. Okay, he bought the tickets, he went there, as in he voluntarily exposed himself there. During the racing, there was an accident that took place. One of the car was thrown among the people who were there watching the race, and as a result of that, plaintiff was injured. The court held that plaintiff knowingly undertook the risk. If there is racing as in such a high speed they will drive, right? So obviously there is a risk involved, because it's not for sure that, okay, this much is the track, they will ride properly, because they are driving so fast. So there is definitely some amount of risk involved. Same ways, if you are going and if you are buying, like you want to watch a cricket match, there is all the possibility that the ball might come and hit you, right? Because you are only yourself going there and watching the game there live, right? You could have watched it on TV, very safe at home, but you only exposed yourself. So you should not be complaining, because there are certain things where risk is involved. Okay.
Okay, ma'am. Ma'am, but these case laws are not mentioned in my notes, ma'am. So is that okay? Like,
yeah, I'll share you. I just added few things. I will share you the revised one.
Yes. Yes, ma'am. Please share me regards.
Similarly, there was another case wherein there was a like company, okay, they were into like producing drinks and all. So there was some like boiling hot water in like one of the containers, all right, and an employee was there. He knew that water is boiling inside it, and he wanted to like remove the lid. Okay, this kind of a cover lid was there. He wanted to remove the lid, but the lid was not coming out. Like it usually happens, right? When it's very much boiling or very hot, it's difficult to remove the lid. Same thing happened here. Now the employee knew that there is boiling hot water, but he still used like enough of force to open it, and he used that much force that it entirely came on him, and he like suffered injury. So he claimed for compensation. It was considered that you have voluntarily exposed yourself. You knew that there is boiling hot water, so you should have been a little careful. If the lid is not opening, might be you should have waited rather than using that extra force that it all just comes on your body, right? You are voluntarily exposing yourself. So this is also nothing but you only consented, or you only did something, you only exposed yourself to the risk while there was no need to do so. So in such cases, you should not be the one who is complaining about it. Okay. Is it clear?
Yes, ma'am.
Okay, so this is the first one, voluntary non-fit injury or the defense of consent. You have given your consent. Same ways, have you heard of Roadies MTV? There is a reality show.
Yes, ma'am. Yes, ma'am.
You have heard
Roadies,
of it, right? So
yes.
in Roadies, what happens is a lot of contestants would go, and then there will be all the scolding and all the insult, humiliation, all that stuff would happen on a national television, right? Now, all those contestants who would go there, they are above 18 years. They will not, allow anyone below 18 years. Why? Because above 18 years, you are considered as entitled to enter into a contract. And before they join the show, they will be asked to sign on a consent form that, yes, voluntarily we are coming here, even though something is insulting or something, we will later on not complain that how come this is, like telecasted on the national television, this is very insulting for us or something. Okay, so they will be asked to sign on a consent form, as in there was no need for you to go in such a show where there is a possibility of, like such kind of things happening. But even then you only went there, so you should not be complaining later on that it was insulting for me or something, because you know what kind of a show that is. That's nothing but voluntary non-fit injury or defense of consent. Okay.
Yes, ma'am. Ma'am, but how can they get permission to conduct such shows, ma'am? Like, if I say that I'll conduct a show, guys, and if you're interested, you can come here. If you come, I'll scold you, I'll abuse you, I will insult you, I will criticize you, and all. Like, how can somebody give permission? It is like, guys, come, I'll kill you, and I'll take.
Yeah, because there are people like dying to go there, and there are people dying to watch the show. There is audience, there are participants, so it's going on.
Okay.
Yeah.
Okay.
Okay.
But no third party can see. I'm not what to say. I'm not this thing over there. I'm not going to participate in that. But as I am the other this thing, third person, can't I go to court and say that such this thing you can't conduct, such shows you shouldn't conduct, you shouldn't be conducting?
There are regulatory bodies, there are like censorship board and stuff, right? So they will review it. A lot of scenes, a lot of things, they do say that, okay, this certain part you just remove it. For movies and all also it happens. Before it is released, they would do it. Same ways for television also, there are certain things which cannot be telecasted, or certain things which might be a little bit like adult stuff that they would say that after 10 o'clock, after 11 o'clock, you can show, not before that. Like that, there are some rules because people are interested to see that, people are interested to take part, it's going on. Some regulations are there, some guidelines are there. Based on the guidelines, they will impose some restrictions, not like you can't insult or something.
That is why it is telecasted late night, ma'am. Usually it is telecasted late night, right?
Yeah. So these kind of shows and stuff, right, which are not good for children, like Big Boss and all also, right, telecasted at like night only, something. Yeah. So next one is plaintiff, the wrongdoer. As in plaintiff, as in who is plaintiff?
The person who is only putting case.
The person who has actually suffered the loss, or who is complaining that, okay, I have suffered this loss, give me this compensation. But what is it? Plaintiff only is the wrongdoer. Usually what happens, plaintiff is the one who has suffered loss. Defendant is the one who has done something wrong. But here what is happening? Plaintiff is filing a case, but plaintiff only is a wrongdoer. He only did something wrong. He suffered injury and now he is only complaining about it. Okay.
Okay.
So it says, from an immoral cause, no action arises. If you are going to the court, you are complaining about something, you are asking for compensation, you should be right in your point. It should not happen that you are only doing something wrong, then you are only complaining. That should not happen. Okay. It is based on a maxim ex turpe causa, which means that plaintiff himself is engaged in the wrongful act or conduct. From an immoral cause, you will not have like an action. You should not be filing a case if you were only the one who was doing wrong. If plaintiff only was engaged in something wrong, then he cannot recover damage. He should not be complaining about it. But if the defendant asserts that claimant himself, as in if the defendant proves that yes, the plaintiff himself was the wrongdoer and he is not entitled to damages because he was only doing something wrong, he suffered injury, now he is only complaining about it. In such a case, it does not mean that the court will declare him free from liability, but he will have to prove that properly. That yes, it was not my fault, but other person only was doing something wrong. Okay, so if I'm going to the court complaining about something, I should not be the one who is at the wrong position. That I should be proper in my position. After that only I can complain about a certain thing. I can ask for compensation. If the basis of action for plaintiff is an unlawful conduct, then he will not succeed in his action and he cannot recover damages. Court will not provide him damages if it is proof that he was only doing something wrong. He should be right in his position. That's very much important. If a defendant asserts that the claimant himself is the wrongdoer, he is not entitled to damages, then it does not mean that the, okay, this one we have mentioned already, right? Free from liability, but he will not be liable under this, and this we have already mentioned. Okay, so when a person, the plaintiff, is going to the court and filing a case, he should be right and proper in his actions. Otherwise, it might be proved that no, he is not entitled. Defendant can claim this defense. Okay, take for example, A enters B's private property without B's permission or invitation. B has not invited A. B has not given consent that you can enter my property. Still, A enters B's private property. And while trying to open the door, he suffers some injury. And he goes to the court and files a case that there is some defect in B's door. I sustained injury. I should be getting compensation. There, B will come with the defense that A was doing something wrong. A is only the wrongdoer. I never invited him. I never consented that he can enter my property. Still, he entered my property, as in he's a trespasser. He himself is the wrongdoer. He has done the wrong of trespass, and while doing that, he sustained injury. So I'm not responsible for it because plaintiff was the one who was doing the wrong. Is it clear?
Yes, ma'am. It is just like somebody entering my home and without my permission or without my consent or without my awareness, and my dog will bite him inside my.
Yes.
The same ma'am.
Same situation.
The same thing, yeah.
Yeah. So now there was this case wherein there were like two persons. Okay. One was above 18 years of age and another one was 16 years of age. Now this 18 years as in he's an adult, right? What this adult did is he asked this minor that, okay, what you do is you drive this, like bike, and that too in a drunken condition. Okay, he was already drunk, minor was already drunk. Still, major said that, okay, fine, you ride this vehicle very fast. And this other person, the minor was riding and the major person was sitting on the back. Now there was an accident that took place and the major person who was above 18 years, he suffered some serious injuries and he filed a case claiming for compensation. So what court said in this case is that for this particular situation, who was doing wrong? Major person was having this bike. He should have, he should be the one who is riding it properly, carefully, but he allowed, first of all, a minor to ride it, that too, who was drunk. That means he was the one who was doing the wrong. He only gave consent to the other person. He only insisted that, okay, you ride, that too very fast. So in such a case, he was not considered as entitled for the compensation. Okay. So plaintiff, the wrongdoer. If you are only doing something wrong, you are not entitled to get compensation. If you are only entering someone's property without their permission, you should not be complaining about any injury that you have suffered. Next one we have is inevitable accident. Now, accident is different, inevitable accident is different. So in general also we say, right, okay, there was an accident that I saw. When I say accident, might be the driver was drunk, might be he was not driving carefully, might be he was speaking on phone or something, right? As in, it might happen that because of carelessness, the accident took place. Maybe because he was not following the traffic rules and stuff. So when we say accident, it means unexpected injury, as in we were not expecting that it would happen, but it just happened, as in accidentally it just happened. So accident means unexpected injury, and if the same accident could not have been stopped or avoided, this accident is such an accident that you could not have stopped it, you could not have prevented it, even though you have taken due care, precaution, whatever best you could do, you did it. Even after that, it's something that it happened only. You were driving properly, you are having a valid driving license, you were following all the traffic rules and everything happened, but still the situation itself was such that accident just took place. That is called as inevitable accident. Okay, accident is different, but so defense is not accident, but defense is inevitable accident. Okay.
Yes, ma'am.
So inevitable accident serves as a good defense, as the defendant could show that the injury could not have been stopped. He can prove that, okay, I was taking all the care, all the precaution that I could have taken, but it's something that I could not stop it from taking place even after taking all the precaution, and I was not having any intention to harm the plaintiff. It's just that the situation itself was such that it just happened. This is called as inevitable accident. Okay.
Yes, ma'am.
Have you studied labor law?
Yes, ma'am, I have studied. Yes.
There is a legislation called Factories Act in labor law. Okay.
Yes, ma'am. Yes.
Under Factories Act, there are a lot of provisions, procedures being mentioned that needs to be followed. One very important one is regarding some safety guidelines, that for safety of employees, workers, or factory workers, certain guidelines need to be followed. Okay. So,
okay,
like in factories and all, there are very big, heavy machines which are running very fast and stuff, right? Obviously, there is a risk involved because all these are machines, right? Any moment they can get damaged or something might happen, right? Some accident may happen. So take, for example, there is a factory. In the factory, all safety guidelines were being followed. There are some heavy machines only skilled employees were allowed to operate the machine, and all the things, precautions were taken. It was properly maintained, everything happened. But even after that, one day an accident took place because the machine suddenly stopped working. There was an accident that took place. This is nothing but inevitable accident, because what you could have done, maintaining the machines properly, asking only skilled people to operate it and stuff, you have done everything. Even after that, because it's a machine, there is no guarantee, something happened, even after following all the safety guidelines. This is nothing but inevitable accident. Okay, in such a case, you cannot make the manager of the factory liable or something. He will say that I did whatever best I could have done. Even after that, it happened, as in it's inevitable accident. Is it clear?
Yes, ma'am.
And because there is a risk involved that anything might happen and you cannot actually make anyone liable, we have provisions like Employees Compensation Act, that mandatorily you need to provide compensation. Some ESI Act we have, right? These are like provisions being introduced that yes, because inevitable accidents can take place, we need to provide some sort of relief to employees. That's why we have like bunch of other legislations also. So this also acts as a valid defense in case of tort. Same ways in case of Motor Vehicles Act, we have a concept of third party insurance, because it might be an inevitable accident. It's just a situation which you could not avoid, and another person ends up suffering loss because of you. That's why it is being made mandatory that if you are not having a valid third party insurance, it is a crime. It's mandatory, you need to do it only, right? Because an inevitable accident might happen, something might happen. Okay.
Ma'am, in the factory, you know, like the machine, the workers who are working with the machine, there will be a sudden failure in the machine which is unexpected. Like it is not because of either careless of the company or factory, or it is not any mistake by a employee, but there will be a problem and there will be people will be injured because of that. Okay, so in this case the injured person can't go to court, but he will be getting all his other benefit, insurance, PF, ESI, all that, right?
Yeah, they do go to the court in order to say that, okay, I'm entitled for, like Employees Compensation Act claim and application. They do file that. I'm just saying that they cannot make the manager or the authorities liable. But yes, under law, whatever benefits are being provided, that they can claim. For that, there are provisions that you need to go to the court. If in such a case, they need to go to the court. Just that you cannot make the manager or the authority liable because it was not their negligence.
Yes. Okay.
Okay, then we have this one case, Assam State Corporation Federation Limited versus Anubha Sinha. In this case, what happened is that there was like premises that belonged to the plaintiff and it was let out to the defendant. Defendant was using that premises as a tenant. Now, in a lot of rent agreements, we see they would say that, okay, you cannot do any repairs and stuff. You need to ask the owner will get it done, right? Might be same situation happened here also. The tenant was not authorized. So what tenant did is, tenant was requesting the landlord to repair some electric wirings because there were some defects that the tenant had witnessed, and he was requesting the landlord that please get this thing fixed. But the landlord was not taking that seriously and he was not doing it. Now, one day there was a short circuit and there was an accidental fire spread. It did not cause any such like major loss or anything. It did not damage the house or anything, but there was this accidental fire that spread because of the short circuit. No negligence was there from the tenant's side. Action was brought by the landlord to claim compensation because of the fire that took place, and it was held that it is an inevitable accident. There was no fault as such from the person because electricity and stuff, there is no as such guarantee. You can't say anything might happen. So in such a case, it was an inevitable accident because the other person was not doing anything wrong as such. which resulted in it. Okay.
Okay, ma'am, I didn't understand this case, ma'am. Sorry.
See, there is a landlord, there is a tenant. Landlord, okay, tenant realized that there are some fixes that need to be done in electric wirings. There are some problems, right? And tenant informed the landlord that get this thing fixed. Tenant was informing, landlord was ignoring, and finally one day there was a short circuit. Okay. Because of that, there was some accidental fire. As such, it did not cause any damage to the property, but fire was there. Because of the fire, landlord asked for compensation, that you need to pay me compensation because of this. But court said that it's an inevitable accident. There was no fault as such from the tenant. He was not doing anything wrong. He was not experimenting with electricity or something. But as such, there is no guarantee of electricity. Anything might happen. So it just happened. It is inevitable accident. You are not entitled to compensation.
Okay, fine, ma'am.
Okay. Same ways, there was this case. Okay, Sridhar Tiwari versus UP State Road Transport Corporation. There was a bus of UP State Road Transport Corporation. There was this bus, and this bus was like, there are certain roads, right? Like Uti and all roads are very small, and like it's very risky sort of a road. So there was similar situation here also. There was a bus coming from one side. There was a cyclist who came in front of the bus, okay, and it was heavily raining. Also, this road was not proper. The driver tried to apply the brake. It somehow did not stop. As a result, the bus hit another bus. Okay, there were two buses and one cyclist. In order to save him, two buses hit one another, and there was this accident which took place because road was not proper. It was raining already, the road was narrow, and all the situation happened. So the situation itself was such that even after applying brake and all, it did not work out, and there was an accident which took place. So it was known that there was no negligence on part of both the drivers. Both of them were driving carefully, but because it was raining, road was narrow, they wanted to save the cyclist and everything, it just happened. So in such a case, it was considered that it is inevitable accident, and UP State Road Transport Corporation was held not liable. That they are not liable. It was just a situation itself was such that it is inevitable accident. Is it clear?
Yes, ma'am. But he will be getting a compensation, right? Because as we discussed in the previous, loss is loss. Like he's anyway is facing the loss, the cyclist.
Who? Yeah, so for that we have concept of this third party insurance and all that, but there any kind of loss you would not get. There also, like for loss we have conditions as well. For what kind of loss you will get, is there liability or not? Insurance companies also look into a lot of details. So that is a different matter. Here we are talking about liability, because in case of motor accidents, right, you can either file a civil case or a criminal. Right, so if you are imposing a liability under this, court said that yes, under inevitable accident, you will be excused from this.
Okay.
Yeah, so third party insurance again is a different matter. Most of the times you would see insurance parties, insurance company being a party, and in such cases, insurance companies also again look into a lot of details, lot of formalities. They try to escape the liability. Okay, so a lot of things come into picture. In this case, whether the corporation is liable or not, being like a government organization, like for their employees, are they vicariously liable or not? That was the question. So they came up with the excuse that it was inevitable accident, something where there was no fault as such.
Okay, ma'am.
Okay. All right. So next one we have is act of God. So have you heard of this before? What is it?
Yes, ma'am. Act of God is because of like earthquake, extreme rainfall, or basically nature upset, tsunami kind of thing.
Yes, right. There is one movie also, oh my God, like entirely based on this concept only, act of God. Like insurance companies and all, right? They would mention in their insurance policy that we are not covering loss caused because of act of God. So there were a lot of people who were filing cases claiming for compensation, and then court would reject that, okay, this is act of God. Then there was one person who filed a case against God, like who is this God who is causing so much of loss? Like that, there was an entire movie. Oh my God, its name is. So act of God is nothing but, yes, it is also kind of an inevitable accident. But in inevitable accident, what happened is there were humans who were playing part. But in act of God, it is nature who is playing its role, right? Nature has done something wherein it just goes out of our control, like heavy rainfall, storms, tides, etc. So act of God and inevitable accident, they look similar, but in case of inevitable accident, human is playing its part. In case of act of God, it is nature who is playing its part. Now, there are certain essentials that we need to satisfy. First of all, it has to be that natural forces are involved, right? It should not happen that I was only watering my garden and then something happened. It should not happen. It has to be a rainfall or something like that. But what kind of rainfall? It has to be extraordinary occurrence, right? But based on different, like places, there are certain things like that which are expected, like the kind of rainfall you would expect in Karnataka, that varies from the kind of rainfall you would expect in a place like Himachal or maybe Cherrapunji or something, where it's raining almost every single day, right? So it depends on what place you are and what is normal rainfall or what is the kind of weather there, right? So it has to be something which is like an extraordinary occurrence and not something which could be anticipated and guarded against. Like in a place like Cherrapunji, it's raining almost every day. So people know and people can expect that, okay, it would anyways be raining, so let's do this kind of a thing, right? So it has to be something which is extraordinary occurrence that we were not expecting, all right?
Okay, ma'am.
Two things we need to satisfy.
Hmm.
So extraordinary occurrence is very much needed in order to prove that. Now there was this case, Kalu Lal versus Hemchand. That's a case of 1957. What happened here is the wall of a building, wall of a building, it collapsed due to a normal rainfall. It was not like a very heavy extraordinary occurrence or something. It was normal rainfall considering the place where the situation happened. Okay, the accident resulted in death of respondent's children. Respondent's child died because the wall collapsed on him, he died, and case was filed. The court held that defense of act of God cannot be pleaded by appellant in this case, as that much of rainfall was normal, something that you can expect, and something extraordinary is needed. If you can expect this much of rainfall, you should have constructed it properly. You should not have constructed it in a very, bad quality that it just collapsed because of this normal rainfall. So in such cases, for normal situations, you cannot say that it is act of God. It can be availed only when it is extraordinary occurrence. Okay.
Okay.
Any doubts still here?
No, ma'am. So the neighbor's wall fell on my vehicle or fell on my home and damaged my things. So in case if it is not God's act, it fell only because of normal rain. So I can go to court, right? So I can go to court.
Yeah.
I can go to court and get claimed because of that. Happens because of his negligence. He either kept the very old wall still inactive, or he while constructing itself, it was as you said, it was because of low quality thing, bad quality thing. So we can get claimed. Okay, fine.
Yeah, you can claim for that. Okay, so these were the first 4 defenses which you can claim. Same ways, we have 4 more. So now we have 4 more general defenses which are applicable in case of tort.
Yes, ma'am.
So private defense or self-defense, what is this defense all about?
It's about if I commit any mistake or any crime which I committed because to defend myself. So example, if somebody come to my home to hit me, if I hit him back, if he's injured, so I won't be liable. This is what I think. I don't know whether it's correct or not.
Okay. Yes. So it is nothing but private defense or self-defense. Even though we use the word private or self, which means our own self. But actually, private defense or self-defense is not just applicable for our own body and property, but also it is applicable for someone else's body and property. Okay, private defense applies for protection of body and property of our own self plus somebody else. When we say somebody else, it does not mean that the other person has to be our relative, friend, or someone. It can be even a random stranger whom I am meeting for the first time. There also, I can use self-defense to save that person's life or property. Even though we both do not know each other, I can still do that. Okay, so private defense is applicable for protection of body and property of our own self plus someone else's. So law has given permission to protect one's life and property, and for that, it has allowed to use reasonable force to protect himself and his property. This is applicable when I am apprehending a threat, when I have a feeling that this other person is about to cause me some loss, about to harm me, about to hurt me. Okay, when I have a feeling that he is just about to do something wrong, and I do not have the option that I will sit, relax, call the police or something. I don't have that much of time because, like you said, somebody entering your house, the person is already there inside your house. You don't have the time and liberty to call police or something. So what you do, rather, you don't, like give up in front of the person that, okay, do whatever you want, after that I will file a complaint. No, law has given you the right that in such cases, you can take law into your own hands. You can try to defend yourself. You can try to prevent that situation from taking place. But one thing is very important here. It says defense. Okay, that means this right or this force should be used only in order to defend body or property. It should not be that a person was trying to hit me, and once I was about to use force, he just tried to escape. It should not happen that I'm running behind him and then I'm just beating him very badly. It should not happen like that. Because this right is not given to me to teach a person a lesson or to make him realize that how dare he do it, but it's given only for the purpose of defense. So I can use it only when I'm having a feeling that any moment this person is going to cause me loss. There only I can use it to defend myself, to prevent that situation from taking place. Okay?
Yes, ma'am.
So if it happens that someone calls me and says that next week, next Sunday, I will come to your house and I will kidnap you. It should not happen that I'm going to that person's house and I'm slapping him, beating him and everything, that how come you say like that. I should rather go to the police because I have the option. I have 7 days left. The person is still just calling me, right? So their private defense is not applicable. It's applicable when there is any moment that it can happen. It's just very immediate.
Okay.
So the use of force is justified only for the purpose of self-defense. Like I said, I should not be running behind the person, beating him and everything. It should be enough for the purpose of defense. If the person already escaped, I should not run behind him. Rather, I can file a complaint. Right? So that is what it is, that it's applicable only when immediate danger or immediate threat is there. There should be an immediate threat to a person's life. Someone enters my house and is threatening me to cause hurt, their private defense is applicable. Someone calling me and saying next month I will do this, there it's not applicable.
Okay.
For example, A would not be justified in using force against B just because he believes that someday he will be attacked by B. Someday is not applicable here. It should be immediate. Right now itself, this person might attack me. There it is applicable. So we can use force in order to prevent the situation from taking place. But this force must be reasonable and to repel an imminent danger. It should not happen that a person was trying to cause me hurt with his bare hand and I'm taking a pistol and just shooting him. It has to be at the same level. If someone is trying to hit me with his bare hand, maybe I can push him or something like that. Right? It has to be of that level. How much is required to prevent that harm? If someone says, I'll slap you, it should not happen that I'm killing the person because that much force was not needed, right? I may hold his hand tight or something like that so that the person cannot use that force. That is what is very much needed over here. For example, if A tried to commit robbery in the house of B and B just draw his sword and chopped off his head, and then this act of A would not be justified for defense, private defense, and it cannot be pleaded. If robbers are there, maybe at max you can lock them inside a room, call the police or something like that. It should not happen that you are chopping head of the person. That's like an extreme situation. That much was not needed in order to prevent. So it depends on the situation and depends on what kind of force was being used, what was the situation like. Depending on that, we can say this is what is reasonable. So what is reasonable force? It basically indicates whatever force was needed to prevent that danger, that much force only you use, not more than that. It's only for the purpose of defense, not to teach the person a lesson, not to give justice or something like that. Not for that. It's only for defense. For the protection of property also, law has only allowed taking such measures which are necessary to prevent the danger. For example, so in case of property also, it should not happen that we are doing like some extreme things. We can do whatever is reasonable, whatever is needed. Like take, for example, there is an, like assumption that any moment, like there might be a theft, robbery, burglary or something might happen. For that, people take precautions, like while sleeping, they would lock their gate, main door and everything. They will lock their windows and stuff. That is nothing but a step that you are taking. There are steps like fixing broken glass pieces on the wall. Have you seen that? Boundary wall, they would fix broken glass pieces.
Yes, ma'am.
This wallpaper is coming. Yeah, like this they would fix, right? So that no one can cross the wall in order to enter the house, because normal people, they would just try to open the gate. They will not try to cross. So this is a very common way that is being used in order to prevent any sort of thing happening at the house. So this is nothing but a reasonable thing that you are taking. Then someone might keep a fierce dog, right? Very dangerous dogs they would keep, and they would even put a photo in the main gate that, like I am on duty or something like that. Be aware of dogs, something like that. So it's not just that I am on duty. They would put a picture also that, see, this is the dog that we are keeping, and like you better do not enter. That means these are certain things which are justified in the eyes of law. But it should not happen that you are just preparing some like trap or something, that you have fixed electricity connection in your entire boundary wall. It might happen that a person normally walking on the footpath simply touches your wall. It's not that the person is having any bad intention, but the person would end up dying. So that's not justified. What is justified is how much ever is required, that much only you can use. Okay. And this is applicable for somebody else's also. That's why we see mostly in public places, sometimes two people would be fighting and then entire public would come, try to separate them and stuff. Have you seen that?
Yes, ma'am.
Right. So what is that entire public, from the entire public might be nobody knew these two persons. Still, they would try to separate them, fix it, because they want to save both the two persons, body, property, whatever it is. And that is justified. Law will not ask the public that why did you do that? That is fine. They have sort of a moral obligation to do it. So they are doing it. Okay. This is nothing.
Ma'am, so like what I said, somebody comes to my home, enters inside my home to attack me, and as you said, we have to apply the force only how much ever required, not more than that. Okay. See, somebody came inside my home, so I can't take a sword and chop his head. Okay, but you said you can just hold him or push him, hold his hand tightly, all that. Okay, but the person who entered my home is like physically stronger than me, where I can't just applying minimum force, I can't defend myself from him. So this moment I will use little heavier things, like I might take a rod and hit him, or something like that, which is really heavy. So then you think I will be liable? But
yeah, in that case, it's
to...
not that, okay, the person is in bare hand, you also should be in bare hand. No, it just says how much is required. If a very strong person comes, whom slaps or beating would not matter, you might take a wooden stick or something, hit on his head or something. But it's not that you would chop off his head for that matter. That's how much is needed, depending on the situation, depending on everything, it would be decided. Not like, okay, bare hand means bare hand, sword means sword, not like that.
Okay. So that's what, like, he came, I hit him, but still I took a wooden stick and hit him on his head or somewhere, but still he is trying to attack me. Again, I have to keep hitting him. Then he will be attacking
how
me.
much is needed to prevent it depends on that person's physical strength, depends on the situation. Right? So how much is needed, that much you use. If he is some like wrestler or something, obviously more force would be required.
Yeah. Correct. Okay, I got it.
Yeah. Then another defense which we have is mistake. Okay, like we say, right? Okay, by mistake I called you, by mistake I sent this message, by mistake it happened. Now, when we talk about mistake, there are two types of mistakes. One is mistake of law, another one is mistake of fact. When we talk about mistake of law, that means ignorance of the law. Okay, it's expected, whether you are a law student or not, it is expected that because you are living in India, certain laws are applicable. It's expected that you are aware of those laws. If you are not aware, you cannot give the excuse that, okay, I never studied law, so I did not know. That is not an excuse. It is expected that you should be knowing about it. Okay, if there are some, take for example, there is a notification coming in that without wearing mask, you cannot roam outside, otherwise 500 rupees fine. You cannot say that I don't watch news and stuff because that is very negative. So I was not aware of it. Plus I'm also not a law student. I don't know about it. So I'm not liable. That is not an excuse. It is expected that if some law is there, some changes are there, you are expected to know about it. So mistake of law is not an excuse. It's not a defense. Okay.
This only in the same thing in some other subject it is there, no ma'am? Something like ignorance of law is not excuse, something like that.
Yeah, ignorance of law is not an excuse.
Yes, ma'am.
Yeah. So mistake of fact is an excuse. Okay. So take for example, if you are saying that, okay, fine, I am just like I'm not a law student, I just studied some normal course and then I'm doing some job and I did not know that I need to pay income tax, how I should be paying income tax, so I was not paying income tax. There, that is not an excuse. You will be fined by the income tax department because you were not paying it. Right? That means mistake of law is not a defense. You cannot give this defense. It's expected that you have knowledge of all the laws that are applicable to you. But mistake of fact is an excuse. What is mistake of fact? As in mistake or misunderstanding relating to some factual situation. Like one day I gave you this example, some shooting is going on for a movie and there is a murder scene in a park. I entered the park and I felt like this is a real situation going on there. I dragged the person to the police station and I wasted 1 hour of their time. In such a case, what happens? This is mistake of fact. I misunderstood the situation. I was not aware that there are cameras being set up. They were shooting for a movie. I was not aware of it. That's why I did it. Okay, so in such cases, it's not that I can simply say for everything that, okay, fine, there was mistake of fact. No, I will have to prove it that, okay, yes, it was mistake of fact. And I was not stupid believing that. Actually, the situation was such that I had to believe on it. Okay, I cannot say that, okay, there were cameras, so what? I ignored the cameras. Cameras are everywhere. I cannot give such kind of lame excuses. Okay, if I can prove that, yes, the situation itself was such that I had to believe it, there was no other option. In such a case only, I can avail this defense, mistake of fact. Okay.
Okay.
So this defense is applicable for torts. This defense is applicable in case of contracts also, where a person just tries to escape the liability. Take, for example, a person might say that, maybe he can say that, okay, fine, he goes to a person who is like a dealer of oil, okay? He is supplying coconut oil, only coconut oil.
Okay.
And there is a purchaser, he wants to buy mustard oil. So he went to the person and said that I need 50 liters of oil. He just mentioned oil. He did not specify which oil because the person thought he is dealing only with mustard oil. And this dealer thought this person knows that I'm only dealing with coconut oil. In such a case, we can say it was mistake of fact. Both the persons did not clarify which variety of oil. And in such cases, this entire contract would not make sense. So they can escape the liability. They can say that, okay, there was mistake of fact. Okay.
Yes, ma'am.
And when we say fact, it has to be some important, some relevant fact. It should not be some random fact that we are bringing. It has to be relevant enough that, yes, the situation itself was such that I believe that it's a real murder that was about to take place. That's why I drag the person to the police station. Okay.
Okay.
So when the defendant acts under a mistaken belief in some situation, then he may use the defense of mistake to avoid his liability. So he can prove that, yes, this was the situation. It was strong enough for me to believe it. And I believed it. If court is satisfied that, yes, actually the situation was such, it's not that the person simply believed on something or assumed something. In such cases, court can, give him the liberty that, okay, fine, you are not liable for it. He can escape the liability. Okay. So there were these two cases which we have. In the first one, it is relating to defamation. Okay, in the first one, what happened is the defendant, by mistake, published a statement. Okay, defendant, by mistake, again, here it is mistake of fact. By mistake, published a statement that the plaintiff has given birth to twins in good faith. He was not having any bad intention as such. He actually thought that plaintiff has given birth to twins. And he published this statement. But the reality of the matter was that plaintiff got married just 2 months before. The defendant was liable for the offense of defamation, and the element of good faith became immaterial in the case. Plaintiff got offended by it. She filed a case in the court, and court said that there are cases like defamation. There are some defenses that you can apply, that you can say that, okay, whatever I published, it is true statement or something. But you cannot come with the excuse that, okay, I was under a mistake of fact. Before publishing something, you should have verified, clarified, and everything. Right? If you are not doing it, you can't simply escape the liability saying that it was mistake of fact. Right? You should have been a little careful before publishing to verify whether the information is correct or not. If you fail to do that, you can't escape your liabilities saying that it was mistake of fact, right? So this defense was not given in this case because court was not convinced enough. If you are publishing something, you should rather be sure about it. Okay. There was another case relating to an auction. So there are some auctions which take place. Okay. Sometimes what happens is, maybe you want to sell something on auction. Okay. You don't want to organize it entirely yourself. So there are some auctioneers who would do it for yourself. Okay. So similar situation happened here. There was an auctioneer and they auctioned some goods of his customers. Customers came and said, these are the goods I want to auction, so help me in that. The person also auctioned those goods, believing that the goods belonged to him. When goods were produced, the person simply believed that yes, because he is bringing it, it belongs to this person, and he sold it in the auction. Later on, what happened is, true owner of those goods filed a case against the auctioneer for tort of conversion. Those were my goods. You have sold it to someone else without my permission. So the true owner or the real owner filed a case against the auctioneer to claim for damages. The court held auctioneer liable and mentioned that mistake of fact is not a defense that can be pleaded here. If you are conducting an auction, it should not happen that you are simply taking the goods. You need to also verify whether actually these goods belong to the person or not, right? Some documents, some bills, receipts, you need to check that also. So if you are not doing it, as in you are being very like sort of negligent, right? You simply believe, they simply do it. So you can't simply escape the liability, because like that you would simply come with the excuse that okay, it was mistake of fact, and you might end up selling everyone else's property. That is not right. Right? So in such cases, mistake of fact is not a valid defense. It was not given by the court. Okay.
Yes, ma'am.
Is it clear?
Yes, ma'am.
So mistake of law is not an excuse. Mistake of fact is an excuse. That too, we have to prove before court that yes, actually the situation was such that I had no other option but to believe this to be true. Next we have is necessity. Now, what is necessity? We say, right, like it's necessity. It's very much necessary, as in it's something which we can't do without. Okay, it is something very much required. So if an act or omission is done to prevent greater harm, even though the act was done intentionally, it is not actionable and serves as a good defense. If I am knowingly taking a risk, okay, but why am I doing it? I want to prevent a greater harm. In such cases, I can give the defense of necessity. Take, for example, there are two persons in a house, A and B. And B is super sick, okay? He is very ill. And A knows it for sure that if I am not able to take him to the hospital, within next 10 to 15 minutes, this person is going to die. His condition is so bad. But from their house to the hospital, there is the road, and their speed limit is 30 kilometers per hour, which is a very less speed, right? Now, A knows it for sure that this person is going to die if I'm not able to take him to the hospital within 10 to 15 minutes. Plus, if I am to follow this traffic rule, I will not reach the hospital before 40 minutes. In such a case, he feels that, okay, fine, anyways, it's early in the morning, there will be less crowd. What I will do is I will take the risk. I will take the risk of breaking this traffic rule. So once you are breaking a traffic rule, that means there is a likelihood that some, like risk is involved. Obviously, traffic rules are framed depending on the situation, condition of road and everything, right? So if you are breaking the traffic rule, definitely you are taking some risk. But why are you taking the risk? Not for fun, because you had no other option. You wanted to prevent a greater harm. Here, there is a likelihood that, okay, breaking traffic rules might end up having something, but here this person is for sure going to die. So you are doing it. Okay, so necessity as in, it's some kind of a situation you don't have any other option. You know for sure this is going to happen, so you rather try to prevent it. Okay, and it has to be strong enough. It should not be that A knows that, okay, there is this rule there, but he still wakes up late in the morning, runs late for the college, and then he's driving or riding. Their code is not going to entertain, right? He cannot say that, okay, I'm running late for my class, I'm running late for my office. But this is something different where the person is just like dying, right? So it has to be such kind of a necessity where the person had no other option. Okay. Now, when we talk about necessity, it's different from private defense or inevitable accident. In necessity, infliction of harm is upon innocent. You are taking the risk that by breaking this traffic rule, I might end up hitting someone. As in, if you are about to cause harm, you will harm some innocent person. That person is not having any fault, right? But still you are taking the risk. But in case of private defense, what you do, you try to cause the harm to the wrongdoer because someone is trying to attack you. There you are using it. So you cause harm to the wrongdoer, but in necessity, it might be some innocent person. Okay. Is it clear?
Yes, ma'am.
In necessity, the harm is done intentionally. I know that it's risky to break traffic rules, still I'm doing it because I don't have any other option. Whereas in case of inevitable accident, the harm is caused in spite of taking all the precautions, making all the efforts. Like in case of factories following all the guidelines, all the rules prescribed by law, still some accident, inevitable accident might take place. So in case of necessity, it's intentionally I'm taking the risk of breaking the traffic rule. But in case of inevitable accident, it's just that the situation is only such. I'm as such not taking any risk. Rather, I'm taking all the possible precautions, even after that it has happened. Okay.
Okay.
For example, performing an operation of an unconscious patient just to save his life is justified. Right? The person is unconscious, the person is anyways going to die, the doctor knows it if some, like preliminary things are not being done. So in such case, doctor is doing that. We might consider that as necessity, that anyways the person is going to die, so rather they would treat him without doing the necessary investigation. So this is nothing but necessity. Another one we have is statutory authority. So what is a statute?
No, statute is no idea, ma'am.
Statute? What is a statute? What? No idea.
Statute is the event done by us, which is allowed to do.
No, act as in I mentioned, right? In between a sentence. If you are getting act with A in small letter, that means action. Then you get it in capital letter, that means a legislation. Like we have Indian Contract Act, IPC. These are nothing but act or statutes. Okay, Factories Act. These are statutes, acts, or legislations. Okay.
Okay. It is a rule which has done.
Yeah, like parliament or state legislature has passed a rule book. That's nothing but a act or statute. Okay, so statutory authority, as in an authority given under some act or statute or a legislation. Like you see, most of the environmental laws, most of the labor laws, they authorize a person that this is what should be done. And you are being authorized to investigate, to see if someone is not doing it, you can punish it also. You can do this, you can do that. Someone is authorized to do something. That is nothing but a statutory authority. Statute has given authority to a person to do something. Okay.
Okay.
And this authority is also a defense that the person can give. So if an act is authorized by an act or statute, whatever a person is doing, that act is authorized. A legislation has given that power to a person. Then it is not actionable, even if otherwise it would have constituted a tort. Like take for example, there are some legislations like Shops and Establishments Act. There is a legislation called Factories Act. Okay, take for example, under Factories Act, some inspectors are being appointed. And inspectors are said that you can enter any factory without permission. Okay, during the working hours, you can enter a factory to see if they are following the guidelines or not. Without giving prior notice, you can simply enter and you can investigate whether they are following the guidelines or not. So otherwise, if a person like you or me enters a factory without permission, we might be held liable for the tort of trespass, right? Without permission, we entered it. But this inspector will not be held liable because he is having statutory authority. Factories Act has authorized him that you can enter, you can do the investigation, because we want that all the factories are following the guidelines. Is it clear?
Yes, ma'am. Yes, ma'am. Got it.
So
it's the same thing with the people who come home for the raid and all. They have same authority,
for raid,
right?
and all. Correct.
Yes,
so it is a complete defense, and the injured person has no remedy except for claiming for compensation in case they used more power than what was given, or some compensation is mentioned under the act. If something is mentioned under the act, only that they can claim. They cannot say that it is trespass or something like that. So it is a very strong defense which we have. Take, for example, National Highway Authority of India. They are being constructed to, constituted to construct highways, widen highways. In such a case, if a person's private property is acquired for the purpose of constructing a highway, the person will be entitled to compensation, whatever is fixed by law. He can't say that they have illegally acquired my property or something. Right? It is an authority given to them because highways are more important, mode of transport is more important. So these kind of situations happen. Labor Law Factories Act, I have already given you the example. Same ways you would see for construction of road, they would simply just block a certain road that we are constructing it. Maybe the construction work could go on for 1 month. You can't say that it is causing inconvenience because they are trying to construct the road properly. They are trying to make it good. Even though you are suffering, it is for a temporary period, right? So you can't say that how come they are blocking the road, because they are having the right or given the authority that you construct the roads, right? They will do that. Okay.
Okay.
Same ways we have for government schools, there are inspector of schools who are being appointed. They would also enter the school and do the same investigation sort of a thing. If teachers are there or not, classes going on or not, everything. For universities, we have NAC, right? Like that, all these different authorities are being established under statutes, okay?
Okay.
So there was this case where what happened is there was a railway track that was constructed. Okay, and when railway track is constructed, there will be non-stop trains coming and going. There will be some vibration, noise, etc. in the nearby area. Right? So because this railway line was suddenly constructed over here, value of the property near this railway track, it went down. Okay, and
yes, ma'am.
Owner of this property filed a case in the court saying that because this railway line was constructed, value of my property has come down, so I should be getting compensation. But court said that rather than your value of property coming down, what is important is railway tracks. Mode of communication is more important. So in such cases, you cannot come up with this defense. It was given that statutory authority. That railway department is given this authority to construct railways, improve connectivity. In such cases, you cannot do it. Okay,
Yes, ma'am.
is it clear?
Yes, ma'am. Clear.
So these are the 8 defenses which we have, and there is this conclusion that you can write that the aggrieved party, even if he goes to the court, the other person is having some defenses that he can try to prove before court. If court is satisfied, then court might, the person may be able to completely escape his liability as well. Okay.
Okay, ma'am.
So these are the 8 defenses we have. Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video.